Okay, so welcome everyone. Good evening, and we are starting this. Let me share the GSTAT Rules Word file. I suppose you are able to see the GSTAT Rules file. Kindly confirm either by unmuting yourself or by sending a message in the chat box. Okay, fine. So let us begin since it's only a half-hour session. Okay, so let me first tell you what is the idea behind taking these sessions. The idea is that now this study is about to start. In my view, still it will take like a few months to 1 year, but it will start sooner or later. It is going to start. And what happens normally now, many of the GST professionals they do not possess the background of previous excise and service tax tribunal experience. They do not have many of them, and many of the professionals are non-advocate professionals like CAs or company secretaries or CMAs or GST practitioner consultants. So they are not much well versed with the court procedures. And when it comes to GSTAT procedure rules, it's more about it's like court procedures. Those who are advocates and those who are practicing in other laws, so they are aware. These procedures are borrowed mainly from CPC as well as the high court procedures. Not exactly like that, but certain things like that. So they are not aware. So what happens? You know the law, you have command over the facts and the law, but because of certain procedural things, when a person is not aware, he doesn't understand because he doesn't know the context, why this particular rule is there, what is the intent behind it. So then it creates an embarrassing situation. So let us be aware of these things. That was the only idea. So we'll go rule by rule in this case. And if you have something very, some pressing doubt which you need to clarify, or you have some very important comment to make or contribution to make, then you can unmute yourself and you can speak. Otherwise, after our session is over, we can have some discussion. So let us start. So firstly, as we see here, no, see, I'm going to be very down to earth and practical in this regard. And some people may be aware, like those who are already appearing before SISTAT, may be aware of certain things. Some may not be aware, but let us start with the basic things. Sometimes things are so simple that we may miss it. So it is necessary to cover those things also. So here, firstly, you see the Gazette of India Extraordinary. Now, below that, you see Ministry of Finance, Department of Revenue notification. Now, important thing to note here is that this notification is not issued as a central tax or integrated tax notification, right? It is issued directly by MF. So, if you try whatever database you might be using, like Taxman or TIOL or TMI, so you may not find it directly under those central tax or integrated tax notifications. But what is the authentic way to get any of the notifications or press release or anything for that matter? The most authentic way is to go to the e-gazette. The government of India has e-gazette, so you can find it there. So this is Ministry of Finance notification dated 24th April. Now it is these rules are framed in exercise of the powers given by section 111. So as we all know, section 109, 10, 11, 12, 13, 14, they deal with the GSTAT, all things relating to GSTAT. So we are not going to discuss much about that, but still we will have some references. So this is these rules are framed under section 111 of the CGST Act. Now, the sections, the relevant sections, they specify that GSTAT is not bound by the CPC, right? Civil Procedure Code, Code of Civil Procedure. It is not bound by that. So GSTAT will, it is neither bound by the Evidence Act, no, Bharatiya Sakhya Sanhita. Now it is changed. So it is not bound by that act also. It is not bound by the CPC, but GSTAT will govern its own procedure. So in order to govern its own procedure, GSTAT has framed these rules, right? So this will be for the conduct of the procedure, like filing of appeals, evidence, orders, conduct of the proceedings, hearing. So as we go through, we will come to know about that. So short title, these are called GSTAT rules. Definitions. Naturally, Act means the CGST Act. Adjudicating authority has the same meaning. Appellate tribunal means this. Now let us come to authorized representative. So as we know, it is already given in the Act also, who is authorized representative. So here, authorized representative means in relation to any proceedings before the stat means person duly appointed by central government. So naturally, for representing the department, they can appoint their regular employee. So usually they appoint various people for various cases. So it is not necessary that they will appoint any advocate, and mostly they do not appoint any advocate for tribunals. So even in SISTAT, it is only the departmental officers who represent the department, and only for High Court and Supreme Court they appoint various advocates or counsels, because before tribunal it is not necessary that only an advocate should appear. So then, so person appointed by government. Second, go to clause 2, Roman 2. A person authorized in writing, either authorized in writing or through a wakalatnama, duly stamped. Duly stamped means as per High Court rules, by a party to present his case before the appellate tribunal as per section 116 to appear, plead or act in this behalf. Right. So we all know that who all are allowed. So all professional CA, CMA, CS, advocate and GST practitioner, GSTP, they are allowed. Plus his relative or regular employee, they can appear. So we will see more about this later. Now bench means the bench of the appellate tribunal referred to in section 109 of the CGST. Now here it is important to note. So as we know, under section 109, there will be two types of benches. One is the principal bench and the other is state bench. Now state benches are also notified. Now section 109 provides that the cases relating to place of supply dispute will be dealt with only by the principal bench, right? Irrespective of the amount involved. And also other types of cases can be notified, which can be heard only by the principal bench. So this is the thing which it may create practical difficulties also. Like there may be small cases involving disputes of POS. So these will go to the principal bench, which will be situated only in Delhi. So for other people all over India, it's going to be a trouble. Now, everything may not be electronic. Although filing is electronic, hearing can be hearing will be in both ways, hybrid. It can be electronic or it can be physical. But still, considering the procedures as we are going to see, if the appeal is thoroughly prepared, documents are thoroughly made and filed electronically, then it's fine. But still, doing it everything virtually may be a difficult proposition. Let us see how things will unfold in course of time. So this is a point to be noted, that principal bench as well as the state benches will be there. Now here, certified copy means the original copy of the order or documents received by the party, or now here both things are included, original copy or authenticated copy. Now in the previous regime, certified copy used to be the copy signed by the departmental officer. Right. So in the service tax, we used to have this problem. Later on in year 2014, they issued a circular. The SISTAT issued a circular saying that self-certified copy is okay. So now and again, submission of original copy also used to be a problem. But here they clarify that certified copy means either original or certified by the concerned department, that is departmental officer, or authenticated by the authorized representative of the applicant or the respondent. So the person representing his CA, CA, CS, advocate, whoever employee, he can file a certified copy wherever certified copy is required. So this is a very welcome and important relaxation. CGST means this is okay. CGST form means forms prescribed under these rules. There are several forms prescribed. GSTAT form 1, 2, 3, 4, 5, 6, and then core diary forms are also prescribed. Now, GSTAT portal means, as we all know, the portal is already functional, not fully, but portal has become active as of now. So, as of now, your registration is allowed. The professionals registration is allowed. Then, now let us come to important thing. Interlocutory application means an application to the appellate tribunal in any appeal proceeding already instituted in such appellate tribunal other than a proceeding for execution of order. Now let us decode this. Now, when it comes to interlocutory application, what is an interlocutory application? Suppose a case is in progress. Now, in this case, appeal is in progress. During the progress, if there are in between some application is required, that is called interlocutory. Mostly, it may be like for injunctions, interlocutory injunctions or stay. Now, in case of GSTAT appeals, there is no question of stay because stay is automatically granted under the act itself. But there could be other interlocutory applications, like, for example, early hearing, or there may be applications for uh, securing witnesses or seeking permission to submit additional evidence. So there could be applications like that, interlocutory applications, and there are rules for handling these applications, how these will be submitted, within what time decision will be taken, and all those things which we are going to see later. So these will be interlocutory. But other than for proceeding for execution of order. Now, what is this proceeding for execution of order? Now, one part is appeal and second part is execution of order. Now, what is execution of order? Now, this concept is borrowed from CPC. Usually, what happens? Suppose GSTAT, suppose an assessee is before GSTAT in connection with a refund. So the appellate authority has rejected, the first adjudicating authority rejected, he went in appeal, the appellate authority also rejected the refund application. Now he is before GSTAT. Now GSTAT ruled in favor of the appellant, assessee, taxpayer. And GSTAT ordered that this refund be granted. The refund is payable, refund be granted immediately. Now what happens? The assessee makes a refund application. Now the departmental officer is not granting the refund. When he goes, the officer says, no, we are going to file an appeal before High Court, or similar matter is pending before High Court in some other case. So until that is decided, we are not going to grant. So for such a number of things, he is not granting the refund. Now, in order to get this order executed, this assessee will approach the GSTAT again, that you have passed the order, but it is not being executed. So you give us execution of this order. Now, as we are going to see later, GSTAT rules also provide that GSTAT may direct a competent court, like civil court, to execute this order against this department. So that will be the proceeding for execution of order. So there you cannot make any interlocutory application. So this is about interlocutory. A member means a member of the tribunal and includes the president and vice president. Party means appellant as well as the respondent. Now here there can be one more concept of pro forma party. Now, what is a pro forma party? Although it is not recognized in the rules, so only time will tell whether these pro forma parties can be added. Like, for example, if there is a case of fake ITC, right? Or if there is a case of ITC denial for 3B2A mismatch. So whether we can join the supplier as a pro forma party. So this time will tell. But as of now, party here means only two parties, the appellant and the respondent. Or of course, any other person making any application. Now specified means specified under these rules. President means the president of the appellate tribunal who is already appointed, as we know. Then principal bench means as under section 109 subsection 3. Rules means CGST rules or SGST ITGST. Section means section of the CGST Act. SGST means SGST, that's fine. Now state bench means state bench under section 109. Okay, vice president of the. Now here, vice president means vice president of the principal bench or state bench, right? All other words have the same meaning as assigned them in the act or in the rules. Now let us come to, now there are various chapters, some 15 chapters are there. Now let us come to powers and functions. Now this is an important rule, computation of period. Now this rule 3, interestingly, what it says, so where any period is prescribed by the act or rules, or under these rules or under any other law, for this tribunal for doing an act, in computing the time, the day from which the said period is to be reckoned shall be excluded. Like for example, we are filing an appeal before GSTAT. Okay. So the date on which you received the order, that day shall be excluded, right? We have to file the appeal within 3 months. So that date should be excluded and 3 months should be calculated after that. So this first part is okay. Now come to the second part. Now this is very interesting. Now what the second part says is that if the last day expires on a day when the office of the tribunal is closed, that day and any succeeding day on which the appellate tribunal remains closed shall also be excluded. Now, this is very interesting. So, now appeal filing is basically, as we see, it is electronic. So, when it is electronic, then should this concession still exist? That is a question. Now, but they have given this concession. Now, while giving this concession, now can we say that it is overriding the principal act and rules, because the act is nowhere giving such concession. No such provision is there in the act, nor in the CGST rules. But can tribunal make such provision? As of now, it seems that this provision will be beneficial to the assessee, taxpayer, because in most cases, the appeals will be filed by the taxpayer only. Very few cases where the department will file appeal. It may file also, but this provision will be beneficial in the sense that if it is the last day, you get one more day, 2 more days if tribunal is observing a holiday. So that is the point. Now, whether this can be challenged as ultra vires the act. Now, sometimes it may so happen that suppose department files an appeal by relying upon this rule by taking the concession of one more day. Now the RCC can challenge. He can challenge the rule also because the rule is ultra vires the act, right? Because the act doesn't provide this. So he can challenge the rule. Now, can the tribunal strike down this rule? No. Tribunal has no power to strike down the rule because it is not a constitutional court. But tribunal may, what tribunal may do is that tribunal may refuse to grant the concession. The tribunal may refuse to apply this rule. If it is found to be ultra wires, then the tribunal may refuse to apply the rule. So that is very much possible. So this is just to be kept in mind. Then format of direct. So now these are procedural things. Ruling, direction, order, summons. It shall be in the name of president. So these are technical things. Okay, let us focus on more important things. Let us go one by one. Official seal shall be affixed. It will be in the custody of the registrar. The custody of the records. So it will be all the records of the tribunal because there will be many. We file only the appeal petition and all our evidence, but there will be court diaries, there will be witness summonses, then there will be a recording of the statement of the witness. So all those things. So those will be in the custody of the records. And further provisions are also made for the inspection. Now, sitting of the bench, a bench shall hold its sitting at locations notified by the central government. Now, here, a welcome thing is that many benches have been notified. Like in Maharashtra, for example, previously, SISTAT, only there is one bench in Mumbai. But for Maharashtra now, state benches are at Mumbai, Pune, Nagpur. These are three state benches, and plus there are circuit benches at Thane and I think one more place. Nashik. Some there are a few more state. So similarly, it is expanded because it is state plus center, but still so many huge pendency of appeals is there, right? So initially we can expect a huge chaos when GSTAT starts functioning. Now, what practically we should do is that now that GSTAT will start functioning sooner or later, we can just keep ready all the appeals. We can draft the memorandum so that when it starts, we should be ready because initially there will be a huge chaos. That is what I expect. Then sitting hours are for the bench, it is 10:30 to 1:30 and then 2:30 to 4:30. Now, sometimes it may get extended. Now, but of course, here it says it shall not prevent the tribunal to extend its sitting as it deems fit. But so far, the experience with Sistat is that generally it doesn't get extended in many benches. So let us see how it goes. But here, the rules provide flexibility to the bench, to the tribunal, to exempt certain things as we are going to see it later. Now, working hours of the office. The administrative offices are 9:30 to 6, that is registrar, matlab deputy registrar, assistant registrar. Now come to this important rule, inherent powers. Now this is very important rule. Nothing in this rule shall be deemed to limit or otherwise affect the inherent powers of the tribunal to make such orders or give such directions as may be necessary for meeting the ends of justice or to prevent the abuse of process of appellate tribunal. Now, the tribunal can give such orders. So, even if there is something, some procedural lapses there from our side, so we can request the tribunal to condone that and to allow the particular proceeding, right? So that is what is important. How you deal with the bench, right? That matters a lot because whenever, as previously also I said, in judicial proceedings, it is four things which determine the outcome. I'm speaking practically, which determine the outcome of the case. So, firstly, it's the merit of your case, right? That is first thing. It's not the only thing. Secondly, how you present your case, right? The advocate, the person representing, advocate in the sense the person representing. So how he represents, that also matters a lot. Ki, what to speak, what not to speak, what to press, what not to press, and also how not to mislead the court. Sometimes one mistake the professionals commit is that, like for example, they will take a case law and they will take only such part which favors them, and other part in the same judgment, if the Supreme Court or High Court has said opposite thing also, then they will not speak it at all. Now, this is like misleading the court sometimes because there is time pressure. The court reads through that, the court trusts you, and so later the court finds that the judgment says totally different thing also, but you did not speak about it. Now this becomes like misleading the court. Now the court may get upset at you. So therefore, it is important that, so what should be done in this case? So we present our favorable part strongly, and we also speak about the negative part briefly. So we don't mislead. So we say, okay, the court says this also, but if you can refute that, if you can take some other view about that, you do that. If you don't have anything to say about it, then what you should do is that you can just briefly mention about it, that it says like that. But in my view, this favorable part is more important, like that. So there is no misleading. So misleading can happen in various ways. So that is where the advocacy skill lies. Ki how you present your case apart from the questions of fact and questions of law, how you represent that also matters. So second part was that. Third part is the bench, the judge. So practically we can see some judges are like, more revenue favored, some judges are like more assessee favoring. So some humans are there, so some bias definitely arises. And fourth part is ultimately your destiny. So when it comes to rule 10, why I was speaking about this is that inherent power. So we can appeal, we can request the bench to exercise their powers and to condone those delays. Like one more small thing in when it comes to this is that in several proceedings, when like in High Court, when you are appealing, if your recently there was a bunch of petitions, writ petitions dismissed by Bombay High Court about Section 148 of the IT Act. Now, in that case, the councils pleaded before the court, you kindly grant us liberty to file appeal under the Income Tax Act. Now, that liberty is existing in the Income Tax Act, but why to specifically get it? So that it doesn't cause any confusion in future that your writ petition was uh, rejected by the High Court. So, okay, that was rejected, but that doesn't mean that all my ways are closed. So, that is specifically noted here. So how you deal these things, so that is very important. So therefore, these inherent powers are also very important, right? So this was the point. Now calendar. Now related rule is rule 13, power to exempt. The appellate tribunal on sufficient may on sufficient cause being shown exempt the parties from compliance with any requirement of the rules or give directions in matters of practice and procedure as it may consider just and expedient on the application mode to render substantial justice. Now, this is important. So, the tribunal has been given all this power. See Rule 14 also. The tribunal can extend the time appointed. Now, which time? Under these rules, right? Under these rules. Like, for example, suppose you file an appeal, the opposite party gets the chance to submit its reply. So there is time limit. But if they fail to submit in time limit, so okay, tribunal can extend. Or suppose department files appeal and you fail to reply, submit your reply within some time. So the tribunal can extend the power. So these rules 13, 14, 10, they give the inherent powers to the tribunal so that there is no miscarriage of justice. Now, how this, now see, this becomes like sort of discretionary powers. We do not want to escalate the matters unnecessarily to High Court. So wherever there are any such procedural lapses from our side, then we should request the tribunal to exercise these powers and grant us the relief. So this is important. Now come to 11, calendar. Now, calendar will be as decided by president and members. So normally all the public holidays will be followed. And important thing is that unlike courts, there will be no vacations, summer vacation, Diwali vacations, there will be no such vacations. So that is important. Now, sometimes for administrative reasons, non-availability of the bench members, sometimes they may not work. That is okay, but fixed vacations will not be there. So that is an important point. Now come to listing of cases, Rule 12. Now, any urgent matter filed before 12 noon shall be listed. Now, this is popularly called as mentioning in court language. Now, mentioning means uh, your case is not listed for tomorrow. It is listed for a after long time, or even it is not listed at all. No date is fixed. But you come and in view of some urgency, you request that my hearing may be taken early. So that is called mentioning. So if any urgent matter is filed before 12 noon, then it will be taken on the next day if it is complete. And if it is extremely urgent, then if it is even if it is filed before 3 p.m., then also it can be taken for the next day. Now this, see, many things, provisions have been made here. So all those things may not necessarily be required to be used in real life. As the time goes ahead, we will come to know about it. Now come to powers and functions of the registrar. So in any court, there are two offices working. One is the judges or the courtroom. So in the courtroom, there are shirastedars or court officers for that matter. And then there is registry. Now the registry does the function of accepting the appeals, then scrutinizing it, then if there are any defects as per the rules, certain documents are missing, certain signatures are missing, certain payments are missing. So all those things will be done by the registry and they will scrutinize, and if it is found correct, then they will admit, they will allot the number. Now, these provisions are made in these rules also, as we are going to see it later. So, registrar will accept it and then he will grant a registry number, and then your appeal will stand admitted. So, even though you file it electronically, then also the registrar will process it, right? So let us see minutely. He will be responsible for day-to-day administration of the appellate tribunal. Now there will be assistant or deputy registrars in every state bench. He will notify the procedure for filing appeal, which rules also say that it will be electronic. Then he will do registration of appeals, petitions, and applications. Now, this is appeals we know. Petitions means others petitions and applications. Like, for example, we want to cross-examine some departmental officer or some party. So we'll make application for that, right? Or some application for condonation of delay or condonation of delay in submitting the reply. So all those petitions, applications, he will scrutinize. Then he will receive the applications for amendment of appeal. Now, this is important. Uh, these rules provide that normally this is like more like high court. In first appeal, what we do, if certain grounds are left, then we subsequently file additional submission. So it's normally done. It's not a problem. But in case of GSTAT appeal, what we have to ensure is that we file our appeal complete in all respects. Because if you want to make any additions, right, then you have to seek permission, and then only you can add. There is a specific rule which we are going to see later. Then only you can add grounds. So our appeal should be complete in the first place, right? Otherwise, you have to, this procedural part increases. Now, usually many benches take these things liberally, they allow you, but still it's time consuming and there is uncertainty also. So receive the applications for amendment of the appeal or petition. Then receive application for fresh summons and notices regarding service. So this is regarding the witnesses mainly, or production of documents. Certain documents were not, like for example, some relied upon documents were not given by the adjudicating authority. So you can make application for that. So these documents were not given to us. The statement of XYZ person was not given to us, but the order was based on that. So you can make an application for that. Application for substituted service of summons or notice. Notice was served on his address. Now, here the ways of service of notice are also given in the GSTAT rules. It is the same as per section 169 of the CGST Act. But suppose if that mode fails, then you allow us, you will make an application that this may be served in a different way. So substituted service. Then orders concerning admission and inspection of documents. So we have the facility of inspection of documents, so we can make application. There is a chapter dedicated for that. Then he will maintain the record, so in detail it is prescribed, we will see it later. Then other incidental matters. Now adjournments shall normally be sought before the concerned bench, and in extraordinary circumstances the registrar may permit the adjournments, right? And he will lay it before the bench in his chambers, not in the open court. So president can delegate the powers to the registrar, right? So I think this is okay for today. Tomorrow we'll go with chapter 3. So if you have any doubts or anything to say about this, you can kindly unmute yourself and you can speak out. Or if you want any other specific things to be covered, we are going rule by rule. So you can unmute yourself and you can ask that. I have deliberately kept it a half hour only so that it remains interesting and it remains practical.
Uh, Thank you, sir. This is CA Hemant from Hyderabad.
Yes, please.
Uh, 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 Thank you for this initiative and giving us a time to go through this rules and all. Maybe I'm starting a new practice where I don't know anything about how the process and procedure is. So maybe, like as you said, how the order should be, how order should not be, and all you are saying, na? Maybe can, if time permits, can we show any sample document saying that this is how it should be and this is how it should not be? Maybe that will help us in understanding in a more better way.
What order?
Something like as you said, like suppose if you want to file an appeal, we have to submit it order in original. So whether we need to say it as a true copy or we need to sign it or something like that.
Mm-hmm. No, you only say true copy. That's it.
That will be sufficient. Yeah,
Right,
maybe
right,
somewhere I have seen that, so I have mentioned it. Maybe if I have not seen it, so maybe I don't know like about it.
right.
Yeah. Thank you, sir.
Yeah. So okay. Any other question?
Hello, sir.
Yeah.
Sir, this is Deep Shah from Mumbai. Um, I recently attended a session on GST TAT rules, GSTAT rules, and wherein speaker said that only practicing chartered accountants can appear in front of tribunals. So I had this query, like when I saw that form, I don't remember form number, but it says that authorized representative slash cost accountant or practicing chartered accountant can represent in front of tribunal. And when I see the authorized representative definition, as you said in the beginning, that any person authorized in writing. So is it mandatory that the chartered accountant should be a practicing chartered accountant, or even if it's just having a job, and then he represents the client on the tribunal? So your views on this?
So you are speaking about a chartered accountant who is not in practice representing his employer or any other person.
Like any other person.
Okay, any other person. In what capacity? In what capacity? In his capacity as a CA or
So yeah, like a CA only, like or a consultant, you may say that way.
if we analyze the section, no, then I think previously I had analyzed this whether a person not holding COP can appear. So I'll get back to you tomorrow on this whether it would be possible or not because he's not holding COP. So because section says chartered accountant, it does not say holding practice, holding COP. So just give me one day's time. I'll get back to you on tomorrow.
Sure, sir. Thank you so much.
Okay. So fine. Thank you very much. So we are stopping here and we will meet tomorrow again at 8 p.m. Thank you very much. I am ending the meeting.